Paul Foster-Bill.
Thank you, Mr Speaker. Sir, the government members on this side will be supporting the Official Information Parliamentary Under-Secretaries Amendment Bill, and it's a pleasure to take a call in the second reading debate. Can I congratulate the member Adrian Rarafe? Having the good fortune to get a bill drawn is one thing, but can I also observe the careful and I think a very practical and pragmatic way he's approached this. I've only come into the process part way through, having joined the Government Administration Committee, which is ably chaired by Ms Dyson. I only joined the committee halfway through the process of considering this bill, but I have to congratulate the member for the positive approach he's taken, even though initially we did disagree with whether this bill was necessary, but also some of the substantive points that it raises. We still have some concerns as to the necessity, and I think that's actually been well illustrated by our colleague Mr Seymour and his tabling of Official Information Act requests that he has already dealt with using the existing system, which makes parliamentary under-secretaries OIA-able via the ministers from whom they hold their delegations in the relevant portfolio areas. So I think that point has been well illustrated. And I still have a few lingering concerns, particularly around the constitutional issue that is raised when you talk about deeming a parliamentary Under-Secretary of State to be, for the purposes of the OIA, a minister. Because the Cabinet Manual is quite clear, and we did hear a wide range of advice on this, not only from Law Commission President in a personal capacity, Sir Grant Hammond, but also from departmental advisors. And it is of concern to me, and I think other members, the constitutional implications of deeming an Under-Secretary to be a minister, because it's very clear in the Cabinet Manual that they are not and were never intended to be a minister, and they certainly don't enjoy any of the other I suppose, support that ministers get. A parliamentary Under-Secretary, for instance, doesn't have access to the VIP transport service, the Crown limos that have already been referenced in this debate, unlike, as Minister Collins points out, the Leader of the Opposition. But also, I think the argument that this presents a potential slippery slope is a valid one, and it's one that we had to mull over at some length, because if one does make a parliamentary Under-Secretary who was never intended to be subject to the OIA, and we actually sought advice from this, and we were, with the historical research that was conducted by the Justice Ministry advisors, they weren't able to find any suggestion whatsoever that it was originally intended to apply to parliamentary Under-Secretaries. This may well have been a very conscious decision made by the forward-thinking, I think, drafters of the Official Information Act 1982, which I guess it should be observed was one of the world's first freedom of information pieces of legislation. It was promulgated under Robert Muldoon's government, and it was at roughly the same time as the Australians went through theirs, but a good 18 years ahead of the British example of bringing in their Freedom of Information Act, which didn't happen until the Tony Blair Labor government. So the OIA drafters, when they originally put this together, didn't intend this to apply to parliamentary Under-Secretaries. So this isn't an omission that has been corrected. It was specifically provided for that Under-Secretaries could be OIA'd via the delegating minister. Therefore, there is a concern that this does present somewhat of a slippery slope, and if we can add in Under-Secretaries, what about parliamentary private secretaries? They're certainly not a member of the executive. They carry out some very useful responsibilities on behalf of their delegating minister. They may represent the minister at functions, for instance. They may give speeches on behalf of the minister. Will that be the next step? Will we make parliamentary private secretaries subject to the OIA? Well, I know Mr Seymour, I presume facetiously, is mooting that as a possibility, but we take it... we take it actually quite seriously on this side of the House, the protection that is provided to members of Parliament when they go about their work and not being able to be OIA'd on, for instance, which constituents they may have met and when, and what briefing that they may have sought from other agencies to enable them to undertake work on behalf of constituents. The privacy of a constituent is very, very important. They may not raise a sensitive issue. If they're having a conflict perhaps with a government department or with local council, as we often get here in Wellington under the current mayor at least, and that may well change hopefully later in the year when we have our local body elections. But I see a number of complaints about our local body here. Would a constituent feel comfortable in raising those with a Member of Parliament if they felt that they may be subject to the OIA and used either as a political point, a debating point by the opposition, or aired through the media using the OIA mechanism? Of course they wouldn't. Similarly, we have dealings with businesses. I assist a number of businesses with issues ranging from visa applications to, again, dealing with the local council, and for reasons of commercial sensitivity with their competitors, but also these might be issues that are private to that company and they simply don't want aired. So for these reasons, I think the slippery slope concern is a very valid one, and I would be concerned, as I think other members on this side of the House would be, should we start adding other categories to the OIA, which was certainly never suggested and not the intention of the original drafters. So I believe that public confidence in government decision-making is very important. It is a wonderful thing that we have an environment in New Zealand where the public can access the full gamut of official information. And having been on the other side of this picture as an official, wielding the black pen and deleting withheld information, redacting information from an Official Information Act request for reasons of national security, protecting our economic interests, saving our friends and allies from embarrassment, perhaps protecting personal information. It may well have been legal advice that was legally privileged. For all assorted reasons of good governance and the protection of the privacy of individual citizens, there are grounds for withholding information, but also I think the wider picture that we need to take into account is to whom does the OIA apply and why that should be the case. So I think we will be joining Mr Seymour and voting for this bill to see it get through to the committee stage. It'll be very interesting to see what amendments members may have to table on this. But you know, we do take it very seriously. There was a discussion with the Office of the Ombudsman and the Cabinet Office because there are wider constitutional issues at stake. And the interesting thing was we were advised that this approach was utterly consistent with the one taken by a former Prime Minister, actually Helen Clark, following the 2002 election when she appointed 2 parliamentary Under-Secretaries. Double trouble, Mr Speaker, whereas currently under this government there's currently only 1 parliamentary Under-Secretary of State. So I think we were actually taking a very reasoned approach. It was consistent with the approach taken by Helen Clark, hopefully the next Secretary-General of the United Nations and former Labour Prime Minister back in the day when the Labour Party held government and were able to present a generally more coherent political argument, I think. So we're taking a consistent approach. Having said that, we will see this through because this is a government which believes strongly in transparency, in good government, in those elements of governance which allow the public to scrutinise, to hold us to account, because on this side of the House, Mr Speaker, we've got absolutely nothing to be ashamed of, and I'm sure should OIA requests flow into Mr Seymour's office, there will be absolutely nothing of any concern to any member of the public, although there may be a significant amount of officials' time devoted to servicing those requests, and let's bear in mind that there will be a compliance cost to this piece of legislation, Mr Speaker. Thank you.